fine, and it continues to increase fines as we go through. It's important to note toward the end of the bill, it's not a very long bill though, we do have two different areas where the FCC or local state law has allowed those to happen. Think of places like prisons or airports, etc., where we're using different technology. Those already are in code and are carved out specifically for those specific purposes where we're using those for other public safety initiatives. Again, I think this is a pretty straightforward bill, and we are glad to answer any questions you or your members may have.
All right, Mr. Curtis, do you want to add anything to what he said on the presentation?
No, just however my horse is back in my name. So Curtis and attorney for the investigation. I think Chairman Elders adequately and excellently described the bill, but happy to answer any questions.
All right, thank you for being with us this evening or afternoon. It feels like evening. It's been a long day. This afternoon as well. Any questions from the committee for the author or Mr. Curtis? No questions from the committee. No one has sought to speak on the bill. What's the pleasure of the committee? Motion to pass by committee substitute from Senator Watson, second from Senator Parent. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous.
Thank you so much, Mr. Chairman. Quickest I've ever been in and out of the Judiciary Committee. I'm going to need to go buy a lottery ticket.
Is there anything else you need today?
No.
Okay, because I may have some more bills coming your way, so I'm going to be asking.
Whatever you need, Mr. Chairman.
Okay, well, thank you for being with us. No other bills while you're here? Nothing else you need? You're good? Okay, that's great. All right. Thank you for being here. Thank you, Mr. Curtis. For the record, I've asked that question, right? Anything else he needed? Probably need some stuff from him next week. All right. Let's move on to Senate Bill 499. Senator Ginn, come on up. And we are. Sure, that'll be fine. Mr. Williams, is that right? All right, Knox Williams, is that what you said? All right, welcome as well. You were good. I didn't even look at it yet. I was just based on what he said. We're working off, tell me if I'm right, LC 394970S. Is that what you have?
Yes, sir.
All right, the floor is yours.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, you know, my district attorney is a fellow named Parks White. He's a great all-American kind of guy. Certainly reads an awful lot of things that would bore me to death. And I don't want to say anything about my Judiciary Committee, but I'm glad y'all are here and I'm not most of the time. He had a last year when Congress was working on the big beautiful bill. If they'd have passed the bill as it started, what would have happened would it would have taken away the federal tax stamp that you get when you buy a suppressor in Georgia. And we want to make sure that we comply with that. Unfortunately, they changed the big beautiful bill and they didn't take away
provisions on initially being debated was the complete removal of suppressors from the National Firearms Act. If that had occurred, these still are classified as firearms under federal law as part of the Gun Control Act. So these would be treated just like rifles, pistols, and shotguns for all intents and purposes. There is some nuance there. Be happy to get into those specifics if we want to split those weeds or hairs. But for the purposes of this discussion, they would still be treated as firearms, which means if purchasing them, you'd have to follow the same regulations as trying to buy any other type of firearm, including passage of a background check and a Form 4473 at point of sale if you're going to be buying them through a licensed FFL, just like you would for a rifle, pistol, or a shotgun. The initial bill was trying to remove them. That ended up not where it landed. The Senate parliamentarian effectively ruled that that was not germane to the reconciliation process. However, the elimination of the $200 transfer tax that had stood in place since 1934 was eliminated. So for the first time since 1934, when that law took effect on January 1st, civilians no longer had to pay a $200 punitive excise tax to be able to purchase a firearm suppressor.
All right, you do have other questions in the committee. Senator Hatchett?
Yes. I'm following and tracking Section 1 through really 4. Section 5, that deals with the unlawful possession of a firearm during the commission or attempted commission of a crime. I'm with the lawful possession and going through the proper channels, but why are we taking it out of Code Section 1611-160 when it's talking about it shall be unlawful for any person to possess or use a machine gun, sawed-off, etc. during the commission or the attempted commission of any of the following offenses?
And I believe that and because we share our district attorney, said Parks White, he was, and this gets, I'm not a lawyer, you got me on this one, but he said that if an individual had a suppressor, said that they used to defend themselves in their home, said and it was not registered, they would be guilty and would have to serve, I think there's a minimum sentence in there. I don't remember what he told me the minimum sentence was, but he said, somebody had a suppressor, if they didn't use the suppressor, they'd be fine. But if they had a suppressor on a firearm that they used to defend their home, they're automatically going to jail for, and I want to say it was 25 years. I'm not sure on that, but that's you probably want to talk to Parks. That was where I think that's where that section comes from right there.
Well, I guess I understand that if you're defending your home. There's also a lot of other defenses that you could have there, but I'm more concerned about, wouldn't a suppressor be the weapon of choice if someone was to go in and try to commit a crime? And I guess, do you have any insight as to why that would be taken out? Because I'm all the other sections, I think, follow the same policy tracking, but this one just stands out to me.
Mr. Williams?
Yes, sir. So to address that, it's a bit of a multifaceted answer. I think it's critical to note that it is basically impossible to use a suppressor in the commission of a crime on its own without a host firearm. The use of those.
This is actually a firearm equipped with a silencer.
Correct.
That's what's taken out. Yeah.
Yes, sir. However, suppressors are effectively inert devices, right? These are devices that reduce the noise of a firearm. They are technically classified as firearms under federal law and under state law currently. However, there is no inherent danger in having a suppressor in any capacity. When you're talking about affixing it to the end of a firearm and using it in the commission of a crime, that will still maintain stiff federal penalties. I believe at the federal level, the use of a suppressor in the commission of a crime carries a 30-year mandatory prison sentence. There are very few laws that are more punitive than that. I guess the question would be really how often and frequently are Georgians being prosecuted for the use of a suppressor in the commission of a crime? I can't speak directly to that yet. I can certainly find that answer. But when you look at federally speaking, where is ATF on suppressors and their impact with public safety? Again, tabling hearing protection discussions, and that I've got significant testimony to dive into that, which I'd be happy to share when y'all hear proponent testimony. But you look at a quote from Ronald Turk, the former number 2 at ATF. He was the Associate Deputy Director and Chief Operating Officer, and this was while he was still at ATF in his official capacity. He published a white paper that said, and I'm quoting directly, silencers are very rarely used in criminal shootings. Given the lack of criminality associated with silencers, it is reasonable to conclude that they should not be viewed as a threat to public safety. And one of the main reasons why is because silencers don't actually silence the noise of a gunshot. You can call it a muffler, a moderator, a suppressor, a silencer can. People use all of those terms interchangeably. These are devices that take a dangerous sound level associated with the use of a firearm and they make it less dangerous. However, the science bears out that even with suppressors, gunshots are still loud enough to the point where you should still wear traditional hearing protections like earplugs and earmuffs. And I don't think that any of us can make a logical assertion that something is loud enough that you should still wear earplugs, but quiet enough to make it inaudible and thus a enhanced threat to public safety. Coupling that with shot spotter technology, there's a lot of discussion around being able to localize and detect the noise of a gunshot, because it's unsuppressed. And again, I think that a lot of that focuses around the misconception that suppressors, again, eliminate the noise. I could pull the trigger on a suppressed firearm in this room and nobody would hear it. It would be loud enough to the point where those of us in the immediate vicinity, our ears would still be ringing, and every single human in this room would think, wow, what was that loud noise that just transpired? Getting back to ShotSpotter, when posed the question about whether or not ShotSpotter technology could detect the sound of suppressed gunfire, the CEO, and I'm not sure if he's still the CEO, but Ralph Clark, who at the time of his interview was the CEO of ShotSpotter, again, that's the law enforcement tool that helps police identify and localize gunshots in cities and urban areas. He stated directly that suppressed gunfire can still be detected by their technology. That was 10 years ago, and their technology has advanced significantly. The effectiveness and the sound reduction of suppressors has been basically the same since the 30s. So there are a lot of reasons why criminals don't want to use them. A, they don't actually silence anything. B, there are significant criminal penalties on the federal side. They make them inherently harder to conceal. When you look at the guns that are typically used in crimes, you're talking about handguns. And adding 6 to 9 inches in length, and if you're actually shooting the gun, these things heat up very, very quickly. And then you're talking about trying to conceal it again on your person. If you fire more than about 10 rounds and you put it on your skin, you are going to get a 3rd-degree burn, in addition to just making them inherently less concealable. So there's a host of reasons why these are rarely used in criminal settings, the primary of which is they don't actually silence anything. But at the end of the day, treating what is in effect a hearing safety device as a dangerous and unusual weapon, especially when these things are in common use with hundreds of thousands of them in circulation here in the state of Georgia, it, from our perspective, just seems kind of nonsensical, if that makes sense.
If I can, Mr. Chairman. So your position is because I guess the firearm would still make a noise and that the silencers themselves are not dangerous, that they should be taken off. And if you have the bill in front of you, it's on line 64. I think if you're committing a crime, and I know not all silencers are created equal, neither are guns. A silencer on a .22 Hornet does a pretty good job.
Sure.
But in this situation, if you are committing a crime and your intent is to use a firearm that doesn't make as much of a noise, I don't know why that shouldn't be I'm just struggling with why that shouldn't be a heightened penalty and why we're changing that.
On that point, and that's a policy question for us to answer, obviously, but what the bill consistently is doing is going in the code where we have sawed-off shotgun, sawed-off rifle, machine gun, or dangerous weapon as defined, and where silencer is included with those other types of weapons, we're consistently removing that. I guess the question might be to answer is, what is the policy difference there when it comes to a silencer versus a sawed-off shotgun, sawed-off rifle, or machine gun, as far as how we regulate them federally or under state law? Why pull silencer out of that category? Do you want to address that?
For me, it's one of those things that I'm trying to help people with their hearing and not infringing on other folks that don't want to have this as much noise. I only shot a suppressor one time, and it was I have a hog problem at my farm. That I use a suppressor on trying to hunt hogs. It doesn't work. The hogs can hear better than I can. So that was my experience with them, and I can't address exactly, but I'll let Mr. Williams.
Go ahead.
Mr. Chairman, thank you so much, sir. So at the end of the day, you look at these items, and the suppressor is the only device on this list that's not actually a firearm. You cannot put a bullet into a suppressor or a silencer, whatever you want to call it, and actually pull a trigger, because there is no trigger mechanism, right? This is an inert device that only reduces the noise of a gunshot. And I think if you don't mind, if I can kind of take a step back and explain sort of the hearing conservation aspect to suppressors and what they actually do, and more importantly, almost what they don't do. I'd love to share some quotes from a lot of different government organizations, scientists, and medical professionals from around the country. So first and foremost, according to Dr. William W. Clark, the director of Washington University School of Medicine's program in audiology, the most serious threat to hearing comes from recreational hunting or target shooting. That is a direct quote. Multiple studies have found that between 70 to 80% of hunters never wear earplugs or earmuffs, almost always because they want to maintain auditory situational awareness when they're out in the field. And nearly half of all target shooters don't consistently wear traditional hearing protection. According to the CDC, the only potentially effective noise control method to reduce students or instructors' noise exposure from gunfire is through the use of noise suppressors that can be attached to the end of a gun barrel. That is a direct quote from a study. According to the National Institute for Occupational Safety and Health, from a separate study, if feasible and legally permissible, attach noise suppressors to firearms to reduce peak sound pressure levels. According to the National Hearing Conservation Association, quote, although firearm suppressors do not completely eliminate the risk of noise-induced hearing loss from firearms noise, the risk can be significantly reduced. Therefore, the National Hearing Conservation Association supports the use of firearm noise suppressors as a form of engineering noise control to reduce hazardous firearm noise exposures. The Academy of Doctors of Audiology echoes the statement by stating, quote, while the use of conventional hearing protection tools such as earplugs and earmuffs are fundamental for preventing noise-induced hearing loss in firearms users, conventional hearing protection alone does not always offer adequate protection from noise exposure. I want to highlight that. Again, while the use of conventional hearing protection tools such as earplugs and earmuffs are fundamental for preventing noise-induced hearing loss in firearms users, conventional hearing protection alone does not always offer adequate protection from noise exposure. What that basically means is that there are many instances in which people can use earplugs and earmuffs in conjunction with one another and still not protect their hearing if they're not using a suppressor. They go on to say firearm noise suppressors can be an effective supplement to traditional hearing protection. The way that we like to view this and the way that the medical community relays this is a comprehensive approach to protection. A layered approach is the most effective way to do that, for the same reason that automobiles that have airbags also have seatbelts and other safety features, right? Like, this is very much a layered approach, and suppressors are inherently different from these other items in as much as they're irrefutably safety devices that help ensure that people who are exercising their God-given constitutionally protected right to keep and bear arms don't have to sacrifice one of their 5 senses when they're exercising those constitutional rights.
We have a question for Senator Parent.
Right. Thank you for being with us, and thank you, of course, to my good friend, Senator from the 47th. I'm all about the hearing protection. I mean, that makes a lot of sense. My research was showing that, that piece could pretty much be adequately dealt with the earmuffs or earplugs. My concern is, to use one recent example, the killer who murdered the United Healthcare CEO in Manhattan had one, and you can see in the video that it was very early in the morning, you probably recall, but people around him, it took them a while to realize what actually happened. And so that would be my concern in like a crowd or a mass shooting situation, or even in that one where you can tell, obviously, the killer had his target, but bystanders, if there is a mass shooting or even just shots getting fired or some crime being committed, people do get caught in crossfire erroneously and die. So it's safer to be able to hear where it might be coming from and get out of the way. So that's why it took the bystander a while to get out of the way. So just curious about your thoughts on that.
There's a study that you have where the listening devices for firearms. What's the manufacturer on that? The for the shot
spotter.
Shot spotter. The technology that shot spotter uses. I don't know if you want to read a quote, but they can still identify a gunshot even with the suppressor on it. And so for me, that's one of those things that I don't know how the shot spotter technology works, but I think that's pretty indicative that while at the same token, if you've been around firearms, I guarantee if car backfires or gun fires, it's probably difficult for somebody that's not a regular shooter to acknowledge what has happened. And that's would be my guess is what happens in New York, because I'm hoping not a lot of gunfires going off in New York City, but because they have some of the toughest gun laws in the country. But that was where for me I kind of wonder the shot spotters, if they have those installed, and were they actually able to identify that at that point?
Right. It seems like you said, the testimony was a lot of people would still be able to tell there was a gun fired, but it seems that isn't the case in every instance. And so then the question for me is just about the public safety aspect in a crowded environment where someone is committing a crime. And, this other gentleman, well, I shouldn't call him that, this other murderer who killed, I can't remember how many people it was like 12 or 15 in that supermarket in Buffalo. He said, I tried to get one, but they're banned in New York. They're hard to get legally. So I think that would have been dangerous in that supermarket mass shooting had he had one.
And what I'm trying to do with this legislation is make sure they still comply with federal law. And so right now it's just one specific federal law, and I'm trying to make sure whatever the federal law changes to, that's what we want to make sure that.
Yeah, and it has not changed yet, right?
That's right.
Right. Okay.
That's my understanding. I'm not a lawyer. You are.
You're pretty smart though. So all right, thank you so much.
And that is correct. And if I may, Mr. Chairman, thank you. And to answer your question, you're talking about the United Healthcare CEO shooting. One of the cabbies that was in queue about 100 yards away, went on the news immediately thereafter and said, I heard gunshots. I didn't really know what was happening. And I think that, if you've ever been around gunfire unexpectedly, you're probably going to enter a state of panic. And I would reckon that was what happened with the bystander that happened to be standing there. I've not personally experienced that. However, I have, witnessed horrific car accidents in person, and even then, it took me quite some time to be able to register what was actually transpiring. The use of a suppressor, honestly, I don't believe had any impact on that situation, or would have had any impact on any of these others. Again, because suppressed gunfire is still incredibly loud enough to the point where I'd be more than happy to take you or any members of the committee out to the shooting range. In fact, the Congressional Sportsman's Foundation, the Georgia Sportsman's Caucus, is hosting a demonstration tomorrow. We would invite all of the members interested to come out and shoot. And I'd be more than happy to show you some suppressed firearms firsthand so that you can hear the difference between unsuppressed and suppressed gunfire. I will be wearing earplugs and earmuffs while I am shooting those suppressed guns. I recommend everybody else do the same. However, that is a personal choice. I value my hearing, and if that's something that you'd like to do, I'd leave that choice to y'all. But the invite is certainly there.
I would add one other thing as a personal note, because it's always revolves around us. So years ago I ran a municipal water system, and the neighboring municipality was in the process of raising a water tank. Said they had a crane collapse during that process, and they dropped the water tank. You can imagine a 100,000 gallon water tank hitting the ground makes quite a bit of noise. Matter of fact, it was heard as far as 10 miles away. I went over the next day to visit the scene and talk to some of the people that were there. They told me they heard nothing. When they saw the tank falling, they I don't know if that's a human characteristic or what, but they said no, we didn't hear a thing. So I don't know. That's kind of one of those situations that. Explain it to me, I'll know something better. But those guys, they told me, they said, no, that fat boy over there, he jumped over that 8-foot fence. See, it's kind of exciting, but
Chairman Bearden, did you have a question?
I did. And as Mr. Williams
Yes, sir.
stated, if you're not expecting a gunshot, excuse me, 98% of people are going to go into panic mode trying to figure out what's going on. Sections 1 through 4, I think, is perfect for the law-abiding citizen with a suppressor, but I don't think I really got a solid answer on Section 5 to why we be striking that part out for someone in commission of a crime to take out or firearm equipped with a silencer. I just don't think I got a clear answer on that. I was trying to get a definitive to why we do that. Line 64. Because we are taking a jump from law-abiding citizens through sections 1 through 4, then we're talking about in commission of a crime here in section 5.
I don't have, I didn't make that change, so I can't really address that. It's a substitute that I was modified, so I.
Yes, sir. The idea is basically making the state statute consistent by deleting the definitions, making sure that it doesn't have something referenced on that. But I'd be more than happy to circle up with you all on that as well. Additionally, I mean, the basic concept is, you know, these are hearing protection devices. They are almost never used in the commission of crimes, including here in Georgia.
And I'm open to if you want to unstrike that on line 64. I mean, I get your point. I understand what you're saying. So you know, that's where for me, in order to continue to move the bill forward, I'm very satisfied to have that unstruck.
Leader Jones.
Thank you, Mr. Chair, and thank you for bringing the bill. My question would be, I'd imagine the language in about silencers was put in for some law enforcement purpose. So I guess my question would be, what has changed from a law enforcement perspective that we now would take it out? I mean, what would be the difference now? I've heard about the hearing and things of that nature, but I'm just curious from a law enforcement perspective, what has changed to where we wouldn't need this particular laws anymore?
The main thing was what was going on the federal level, because we want to make sure they're compliant with federal law, but we don't know what the federal law is going to massage around to make. And so the idea that my district attorney brought to me was, he said, hey, if they had passed the big beautiful bill, you would have made criminals out of everybody that had a suppressor, because they can't have that federal tax. I don't know if you call it a stamp.
Yes, sir.
They couldn't get a federal tax stamp, and so for me, that was the intent of the legislation that my district attorney brought to me.
Yeah, Mike 6.
Thank you. And I may be completely wrong, but I think on that 63, page 4, which persons have kind of pointed out, I don't know if you can unstrike that, or because if you're making it legal, you can't enhance a penalty because you're basically legalized. So you'll be able to enhance the penalty if you're using a legal device. When you say unstrike it, you can't, because you have a legal device there. So you can't enhance a penalty if you're losing a legal device, I wouldn't think. That's just my take on it. So in other words, I think you're kind of stuck there.
If it's federally legal,
we haven't got there yet.
And then they use it as in a crime. Said, I'm not a lawyer. No, you are. So I'll leave it to you, because you actually were a prosecutor, I believe, in your past, and that's where, you know, I'm looking for how do I get you comfortable with, okay, let's don't take that portion out if that's what's the issue. And
I just want to clarify, because I keep hearing that, is it federally legal now or not, or we think it's going to be coming?
It is federally legal if you buy the tax stamp. Said okay. And we're saying that it's still going to be compliant with federal law. So whatever
Can I make a statement? Let me know if this is correct. Currently, under federal law, if you have a silencer with that tax stamp, as you call it, then none of these laws we're amending currently applies to someone possessing a silencer. Is that correct? Based on the current language in lines 44 through 48. Mr. Walker, am I right on that? Okay. Because I think the only thing, it seems to me what you're doing, the biggest change here is on line 48. Because you do go outside the National Firearms Act and say, well, any of these items that someone legally has in accordance with federal law, then these enhancements in the illegal possession do not apply. The problem is if we strike the last section here, the change in the last section, and leave the silencer there, then I think we also have to change line 47, because suddenly we're going to expand the current law when it comes to silencers potentially. Does that make sense? We may be going another direction and having silencers that are allowed by federal law suddenly now be a sentence enhancement when someone's using those. Am I correct on what I'm saying?
Mr. Chairman, I believe that is the case, and you're absolutely correct in your characterization of lines 47 and 48. This is intended to make sure that any changes to the National Firearms Act and federal law changes, that Georgians are still able to possess and purchase these lawful items. They have always been lawful, even though they've been federally regulated since 1934. They have always been legal for civilians here in the state of Georgia. So yes, sir, I do think that that's a fair characterization. I believe that strike through was something that came back from Ledge Council.
So currently, looking at lines 44 through 48, then, and somebody correct me if I'm wrong, under current law, the enhancements we have dealing with silencers are not applicable as long as someone is complying with federal law, right, and possessing that.
Currently, it's as long as they are authorized to possess and have registered these items, including silencers, with the dictates of the National Firearms Act.
So your goal of the bill is, in the event this is no longer even regulated by the feds, suddenly we're going to have this new outlaw under Georgia law you're trying to get ahead of.
Correct. Yes, sir. And in our legislative initiatives at the federal level, we also have almost three active lawsuits. We're filing our third this week, fingers crossed, challenging the inclusion of these items in the National Firearms Act because it was justified as a registry tracking taxes paid, and now that there are no taxes being paid, our assertion is that it's an unconstitutional firearms registry. But even if we are successful with our litigation or our legislative initiatives, these still will be federally regulated under the Gun Control Act, so they'd be treated and regulated very similarly to rifles, pistols, and shotguns. It's not as if there would be no federal regulations on them. They would just be outside of the dictates of the National Firearms Act, and having that included in Georgia state statute would create a direct conflict that would, at a minimum, prevent Georgians from being able to make or purchase these items moving forward.
All right, we do have three others that want to speak on the bill, but we'll take. You want to ask your question now? Okay, go ahead, Senator Hatchett.
So just my philosophy on the Second Amendment, as in my position, is very strong. I mean, I'm very in favor. I think it goes a lot further than we allow it to. But with that being said, I'm for everything in this bill except for that one section. Looking at the types of offenses that this would enhance, two of them are breaking and entering into a vehicle, breaking and entering into a house, where I think someone would use a silencer to be more covert. You don't want to be heard. And I think in that situation, I'm going to be inclined to try to amend it to take that section out, because I do think it should still be in there based on just, I'm all for protecting lawful abiding gun owners, but this is not that. So just want to, if you have any rebuttal to change my mind, I'd be glad to hear it. But otherwise, I think I'm at least at some point during this committee hearing, we'll try to amend that.
Mr. Chairman, and I'm going to have to add $1 to that. I'm not a lawyer, Jar.
Frank already owes 3. We're keeping count. You've said it 3 times. We raised the fee this year to $5 per offense.
I get it. I'll bring my lawyers next time, said they, but I think there's plenty on the committee.
That's $15 you owe us right now. We haven't voted yet on your bill either. Might be a good time to pay. Let's do this. Let's hear from the other speakers, and then we'll come back. So if y'all will move back to the bench behind you. Let's bring up Heather Hollett with Georgia Majority Gun Safety. Is it Miss Hollett? Am I saying it right? Hallett. That makes more sense. Welcome, Ms. Hallett. The floor is yours.
Yes, so Georgia Majority for Gun Safety, we are a coalition of gun owners. It's bipartisan, non-gun owners, but the bottom line is trying to encourage responsible gun ownership in Georgia. And I think that there was a lot of comment that kind of teased around the central issue here is that there is, we want to promote public safety and we want to protect public safety. And I guess balancing that with like, why are we trying to pass legislation? And it seems that the rationale is to protect hearing. And we know that there are devices that can protect the hearing for people who are shooting guns. And I think that in the testimony, the gentleman said that 70% of hunters are not using those hearing protection devices. So given that there are some real concerns around people using silencers in the commission of crimes, and I'm happy to send you a listing. I mean, I just did some quick research. There's plenty of times when silencers are used in the commission of crimes. I think it's just reasonable to understand that if you have something that suppresses the sound of a gun, that it is going to be harder for law enforcement to detect where that gunfire came from. Whether or not it's because people are in shock or because the sound is muffled, there's a reason why criminals are trying to use silencers. So there definitely is a public safety component of why would we pass this bill? And given that there are ways to protect hearing that don't involve jeopardizing public safety, I guess I just am wondering what the rationale, why would we be passing public policy when there is a real defined risk to public safety? And again, I just echo Senator Hatchett's comments that in effect, the only outcome of this legislation right now is actually to decrease penalties on criminals in the commission of acts with a silencer. So I feel like the majority of Georgians expect better out of our legislature. We expect public policy that will protect people, not criminals. So just weighing those two things, I think, is my basic comment. Thank you.
Before you go, do you know under Georgia law if anybody's currently being prosecuted for these enhanced penalties for using silencers in commission of a crime?
I saw that there was a gentleman in Macon in 2025 who it was possession of silencers, but it seems like that gentleman was intended to do harm. It was like 3D printing of machine guns and silencers. So I can only imagine that he was not trying to protect his hearing.
And do you agree that under current Georgia law, if you've registered your silencer, that these laws don't apply at all to it now?
Correct.
Okay.
The only change from this bill, the only active change from this bill would be to protect criminals.
Okay, unless the federal law didn't regulate this at all, then we would be, without changing it.
Correct.
We would be, and so do you have an issue if the bill simply made certain that the current law stayed as it is? In other words, as long as someone is registering a silencer, at that point, would you have issue with a bill that confirmed that someone could have legally possess a silencer under Georgia law and use that weapon?
So
on a gun?
I'm at risk of, I don't have cash, so I can't put anything in your glass.
I want to get $20.
But my concern would be the loopholes in our background check system in Georgia, and that I would have to dive in to make sure that all silencers, if federal law were no longer to require the registration, that we would make sure that all silencer purchases were actually required to go through the background check system, because about 25% of our gun sales are not subject to background checks. So that would be my concern. But again, read your glass. I don't know.
Okay, that's fair. Any other questions for Ms. Hallett? All right, thank you.
Thank you so much.
Next, we have Mike Greenwald. Is it Clinicians for Gun Safety? Okay. Come on up.
Thank you, Mr. Chairman. I represent a broad array of clinicians in the state of Georgia, some emergency medicine physicians, some psychologists, nurses, therapists, who take care of people every day from gun violence. I see and treat children who suffer gun violence injuries on a regular basis. That used to not be the case. It is the case now. There are a number of things that these families and my colleagues ask for the real problems that we face in Georgia right now. Silencers is not among them. I want to make it very clear that my colleagues are not asking for silencers. The American College of Surgeons, which is the organizing body that manages trauma in our country, is not asking for silencers. What we do want is some common sense regulation to help bring down gun violence in this country. If the sound of a gun saves the life of someone because of that split-second reaction to that loud sound, then that's an important difference to make. I would urge you to not pass this legislation.
Are there any questions for Mr. Greenwald? Thank you. Next person is Thomas Weaver. Come on up, Mr. Weaver. Good afternoon.
Good afternoon, Mr. Chairman. How are you?
I'm good. How are things going for you?
Life is good.
Good.
Thank you. To each member of the committee, I can maybe help assuage some of the concerns and answer some of your questions. So, if I may, Mr. Chairman, with the assent of your colleagues, when the United States Federal Congress first passed the United States National Federal Firearms Act, it was passed in the 1930s during the Al Capone gang area, the Roaring 30s, right? The United States Federal Supreme Court ruled in 1939 under the leadership of Chief Justice Hughes that the NFA can stand under the court's understanding of Second Amendment jurisprudence at that time. Fast forward to today, the Bruin Court has overturned predicate decisions and has reversed intermediate means-end scrutiny analysis and has displaced it with a historical text and tradition that requires that any federal or state level firearm regulation be contorted and comport to at either the time of the founding or the framers, although there is argument still as to which one is controlling. There was an interceding Fifth Circuit Court case at the federal level in the Fifth Circuit, which covers Texas, Arkansas, and Louisiana, governing suppressors specifically. And the Fifth Circuit held in 2025 that the regulation can stand because it's supported by Congress's taxing power for the $200 tax stamp. The United States Federal Congress recently, under the One Big Beautiful Act, eviscerated and reduced to zero the underlining taxing component of suppressor regulation along with other firearms under the NFA, inclusive of short barrel rifles, short barrel shotguns, and what's called AOWs, to zero. So the question now before the court is, since because the Supreme Court previously held that the only reason why NFA is even a law at all is because of Congress's power to tax. Now that Congress has removed all taxing authority in respect to such weaponry, does those regulations then crumple? So that's answering to the legal status as to why it is the way it is right now. Going to the public safety question that was raised by Senator Hatchett and others, I can learn to better appreciate the governing majority's concern as to whether or not removing a silencer on line 64 would open up the possibility for a bad actor to escape enhanced criminal penalties. But what was noticeably absent from the committee's consideration was Georgia Code Section 1611-106 and 1611-133, which aren't touched under this bill and which remain intact. 1611-106 is possession of a firearm during the commission of certain crimes, and 1611-133 is possession of a firearm by a convicted felon during the commission of certain felonies. Those crimes continue to remain intact, and akin to the United States Federal Armed Career Criminal Act, which is 18 U.S.C. 924, subsection C, paragraph 1, capital B and C, anyone who possesses a suppressor twice during the commission of any felony is subject to an automatic sentence of life imprisonment before the district court at the federal sovereign. And in the state sovereign, if you're a convicted felon already and you have a suppressor during the commission of a separate and distinct felony, what's the right word? Either concurrent with or in addition to a separate and distinct predicate felony, then you're also subject to a term of life imprisonment under 1611-133. And under Georgia law, unlike the federal sovereign, life is with the possibility of parole unless it's sentenced as life without the possibility of parole. But if you're sentenced to life sentence under Georgia law, that's 30 years to the door before your first parole board hearing. So if a person, if a person uses a firearm, whether armed with a suppressor or not, during the commission of a felony, certain felonies as spelled out under Georgia law, that's going to draw an automatic sentence anyway. And if there's a suppressor on that gun, the case can then be referred to the United States Federal Attorney General's office for prosecution within the federal sovereign, and depending on where you are in Georgia, either the Northern, Central, or Southern District Court, which also under the ACCA mandates mandatory minimum penalties, which again, under federal law, all penalties are spelled out in months, not years, and are served without the benefit of probation or parole because the federal sovereign has eliminated that. So if you get sentenced federally, whatever the judge imposes, that's what you serve. There is no safety outlet. If the judge says, because the previous speaker is right, under the ACCA, it's a 30-year draw for strike one automatically. So that's 360 months. That's 360 months to the door. There is no probation or anything like that under the federal system. So from a public policy standpoint, removing it here, I would imagine, without speaking on behalf of anyone, just me, having done this for so long, if I had to guess, it was just a legislative drafting component that maybe the LC council who drew this bill, they just struck the word silencer, which is a term of art under federal law. The term silencer is used under federal code, but it's used interchangeably with the words suppressor and muffler. When a firearm is equipped with a silencer, the decibels that it reduces is usually about 20 decibels per shot. It goes from about 140 decibels to about 120, which is still loud. That's as loud as a jet engine at Hartsfield taking off. So if you were standing at Hartsfield Jackson International Airport and you heard a Delta jet as it was taking off, you would hear the roar of that jet engine. You would also hear the report of the discharge of a firearm armed with a suppressor. It's just a cylindrical piece of metal that functions just like a muffler on a car. You can be obnoxious as possible and you can remove the muffler from a vehicle to just make more noise, but the suppressor is just a little piece of metal. It doesn't shoot anything in and of itself. Why it was put in there by Congress in the 1930s, I didn't have an opportunity sitting in the back bench to read through the journal to find out on congress.gov, but those are just thoughts, and I was hoping to maybe clear the air on some of the things to make the governing majority more comfortable to keep the bill fully intact and move the bill in its current form, akin to how our friends and colleagues did across the marble earlier today at the state capitol building.
You have a question from Leader Hatchett.
Thank you, as always. It's a pleasure when you testify, and I'm always impressed at your knowledge of not just our code, but the federal code. So are you saying that this is duplicative and we don't need it because the federal law would supersede this anyway?
Right. So if an individual were to be illegally armed with a firearm equipped with a suppressor and were to come in here and commit a crime under federal law, not state level, we're talking about the federal sovereign. The federal sovereign, the United States Federal Department, or excuse me, I misspoke. The United States Federal Bureau of Alcohol, Tobacco, Firearms, and Explosives, agents within the Bureau could apprehend that bad actor and could take that bad actor into federal custody and can commence federal process against that bad actor in the court of law federally. And under federal law, if that bad actor is adjudicated guilty of having committed a crime that falls within federal law and they use that firearm that was equipped with a suppressor at the time of that crime, under the ACCA, the district court judge doesn't have any discretion in the matter. The district court judge has to impose a 360-month term on that offense. And then if that bad actor then again commits another firearm crime under the ACCA, another one, doesn't matter what, another one, under federal law they're sentenced to life under the ACCA, which the Supreme Court did uphold in other cases recently, even though there's some provisions regarding bifurcated punishments and what latches when, but the overarching structure of ACCA has been upheld federally.
And just one follow-up. So I use the word duplicative, but in essence, it's concurrent with federal law.
This would be concurrent to federal law.
The change or before?
No, as it stands right now, the law as it stands today, it authorizes state agents to move forward on a state level prosecution within the state sovereign. But even if this is what I'm trying to tell you and other members of the governing majority is even if line 64 stays intact and y'all move the bill in the LC version that it is in with no amendments, if a bad actor within the state level commits a crime armed with a firearm during the commission of certain felonies, that's either 1611-106 or 1611-133. And if they're a convicted felon already, that's also 1611-131, right off the rip. So at a minimum, they're looking at 5 or 10 years, depending on their GCIC. And if it's certain crimes that are in their GCIC, as opposed to just any generic felony, they're looking at a mandatory minimum of 15 to life at the state level, regardless of whether or not the firearm they use either was equipped with or not equipped with the suppressor. So having this here saying we're going to treat a firearm with a suppressor more serious, I understand why that can make some people nervous to take it out, but if you do take it out, 1611-106 and 1611-133 are still fully intact and can still be charged as counts on the indictment, and those draw mandatory minimums that are not probatable and that cannot be reduced to misdemeanors under 1710.5. Nothing changes. It's just removing, for legislative drafting, it's just removing the same term throughout Georgia code such that the word silencer under our firearm laws no longer appears, but it's consistent.
Your questions for Mr. Weaver. Thank you. Appreciate your help as always. All right, that's everyone that's signed up to speak on the bill. Do you want to come back up? Any final thoughts? It seems like to me we have, and it's a policy question of whether we're going to still include silencers as an enhancement in other types of weapons. And we have machine guns, sawed-off rifles, sawed-off shotguns. Are we going to still have silencer in that same category or not? But I'll say to the committee, if you're going to do that, you can't just strike Section 5 because silencer is a defined term under this code section, and we are striking the definition in Section 1 of silencer from the law. So you'd have to now create a new definition of silencer or leave that definition in place and just have this one code section still applicable. Any final thoughts from the author before we consider the bill?
I'm only thinking about my last $5 I got. So but I think the chairman, who actually is an attorney, said, I think you're wanting to be a general attorney, if I'm not mistaken.
That's right. The country lawyer.
The country lawyer. That's said right. You said it better than I could. So thank you.
All right. What's the pleasure of the committee? Motion to pass from Leader Hatch. Is there a second? Second from Senator Bearden. Any discussion or amendments? Leader Hatchett.
I would like to propose an amendment.
Okay.
For clarity, before I do this, Did you say we were striking the definition of a firearm equipped with a silencer?
And Mr. Walker's going to want to weigh in, but I believe under Section 1, silencer is a defined term under this section, and we are striking that. And I think that's why the bill's drafted like it is. Everywhere silencer is referenced, it's taken out. I'll let Mr. Walker weigh in.
Yes, sir, that is correct. I will point out that the definition for silencer is unique to a particular part, and I use part specifically, of the code that would not include the code provision that's in Section 5. So it would still have utility as a definition, but it would essentially be a definition without a term.
So in other words, it'd
just be a dangling definition, and the reason we keep it in there is because we're relying on it elsewhere in the code, but it actually would not be defining any term used in that part for that purpose. So it's a fine solution. It's just a little bit messy and subject to being kind of cleaned up in code revision at some point along the way.
As chair, if the intent is, if the committee is struggling with the final section, I think it's best we hold the bill and work on some language. If the intent of the committee is to strike the changes in Section 5 of the bill, I think we need to hold this and make sure you have a clear definition of silencer, because you're not going to have any federal law to reference. You're going to create a new definition, and we may not get to where we need to be on the bill if that's what the committee wants to do. Was it your intention to offer an amendment?
Yeah, my amendment was going to be to take out the strike of or firearm equipped with a silencer.
I think we should hold on the bill unless somebody has some strong objection. We have a motion to pass. I'd suggest withdrawing your motion. We have 2 more committee hearings at least before crossover day, and we could work on that language if that's what we want to do, and make sure it's what we want to do.
I would suggest a floor amendment at this point, but I don't know what I'd be stepping into on that one.
I don't
Trying to amend the gun bill on the floor.
We don't want to do this on the floor. Who made the motion to pass? Was it you?
It was.
Do you want to withdraw that motion? Let's do that, and let's work on the language. I'd suggest y'all get with the committee members that have asked these questions, and let's make sure we have a clear understanding of what we're doing. We've kind of gone back and forth a little bit on that some, and then if that's the intent to draw an amendment like that, I'd work with Leader Hatchett and make sure we have it drawn correctly.
Thank you, Mr. Chairman. I will say one
Hold on, your mic's off. Now you're back.
Thank you, Mr. Chairman. I will say one other thing. Said this is the 3rd time in 16 years at being in front of Judiciary. And the first one I withdrew the bill. The second one you helped me just like this with the bill. Said and yes, I'm not a lawyer. Said but I'm going to get $20 in this picture somewhere. So
and for the record, the money does not go to the chair or the committee. Money goes to a charity, which will be selected by the committee at the end of the session. Is that good? Did I clear that up, Elena? All right. Okay. Thank you. Appreciate y'all's work.
Thank you.
And so we'll work on this and get it back on another agenda. All right.
I'll bring some more lawyers next time.
Please. Is Chairman Dolezal in the room still? Come on up. I'm gonna take you out of order based on the number of people that are signed up to speak. Come on up. We're gonna call Senate Bill 486. And this will be at the end of your packet, members of the committee. We are working off of the bill as filed, LC 492550. Is that what you have?
Yes, sir.
All right, the floor is yours.
Thank you, Mr. Chairman, members of the committee. Thank you, Chairman, for hearing this bill. I saw Chairman Meeks in the hallway, and I told him I'm always nervous testifying before the Judiciary Committee because I feel like everyone is smarter than I am. And he said, that's how I feel when I come to the Senate. So I'll give you a second to let that sink in. But Senate Bill 486 really builds on existing Georgia code to make sure that we fully enshrine essentially a legal framework that has made its way into the law of 13 other states. It's referred to as American law for American courts. If you look at the existing code that we're building on here on line 25, the existing code states the laws of other states and foreign nations shall have no force or effect of themselves within the state further than is provided by the Constitution of the United States and is recognized by the Comity of States. So we are really doing two things here. One, we're defining foreign law, and that's what you'll see on lines 18 through 22. And then we are ensuring that tribunals are captured into essentially what I believe is the current spirit of the law as outlined on line 25. So what we have seen is foreign laws make their way into American courts in a number of ways. One is the enforcement of foreign judgments via comity, the application of foreign laws through conflicts of laws, the enforcement of choices of law clauses that exist in contracts. We actually deal with some of that on lines 36 through 41. And then lastly, a number of arbitration clauses and the what we've seen in other states is religious-specific arbitration tribunals that have popped up and sought to replace the court system in those states. And Texas is one example of where that has happened, that the governor of Texas has specifically spoken out about, and I can outline that more if the committee would like. But the meat of the bill really captures tribunals on lines 30 through 32. And all that we're saying is we're not saying the tribunals have to go away. We are saying that the tribunal's ruling shall be void and unenforceable if essentially they try to supersede any of the rights granted to citizens under the United States Constitution. And that is the core of the bill. We exempt religious entities on line 35. We exempt international arbitration on line 34, and they already referenced the corporate carve-out. So with that, Mr. Chairman, I'm happy to answer questions. I probably would prefer to reserve the bulk of my time for to come up after folks have testified, as I know there's a number of people that have signed up to do so.
Yes. Any questions for the author before we move on to those assigned to speak on the bill? All right. We're going to do this. We have a number of people signed up. I'm going to do 20 minutes against the bill, and we'll do, I think there's only one speaker sign up for it, but I'll give the same time for the bill. So we're going to start the clock and do 20 minutes, and I will call you up based on when you signed up to speak. And if you want to give your time to someone else, you can pass on it to someone else on the list. Are you going to start a clock for me? Yeah, 20 minutes. All right. So we're going to start the timer when the first person comes up, and we'll stop it for any questions from the committee. So the committee, if you have questions, you will not interfere with the timer of those that came here to speak. Ms. Megan Gordon, up first. Come on up. And now I can say good evening, right?
Yeah, I was just thinking, I don't know if it counts as afternoon or evening or where that line is.
It's
but
evening now.
It is good time to you all, and thank you for your time. My name is Megan Gordon. I'm the policy director at the Council on American Islamic Relations, Georgia chapter. We're a Muslim civil rights organization. And I confess that I am winging it right now because I want to draw your attention to something that didn't come up in the presentation of the bill, which is that a couple weeks ago, after he introduced the piece of legislation, the sponsor posted a video on the website formerly known as Twitter, saying that the purpose of this bill is to ban Sharia law, which is, some folks will come up after me to elaborate on how that is not a thing in the way a lot of people think it is. But it is clear that the purpose of the law, whatever it is to target the faith and practice of Muslim Americans. And that is a First Amendment violation. Facially neutral language does not save a law that is motivated by religious animus. This is very clear. And now that I have addressed what this is about more clearly, I want to talk about some of the ways that this could actually be disruptive to family law. There are clear instances in family law where foreign laws need to be applied. I'm going to give you all two examples. First, so my colleague Robert, he married a Bangladeshi woman. They were married in a Muslim ceremony in Bangladesh by an imam, which is just a Muslim preacher, and a notary from the Bangladeshi religious ministry, because that's how marriages work in Bangladesh. In a Muslim tradition, the marriage is very much a contract. It places obligations on both parties in the event of a divorce. It's a lot like a prenup. If Robert and his wife were ever to get divorced here in the U.S., a court would not be able to base its ruling on the marriage contract that they agreed to and entered into willingly because they did it in a foreign country. Let me give you another example. Our national office recently had a case where an American family of Moroccan ancestry went to Morocco, adopted children there, and brought them back home to the U.S. Because the adoption was done in Morocco, the adoption documents were based on Morocco's Sharia-based legal system. If for any reason a court ever wound up looking at that adoption, it would not be able to consider the actual adoption documents at issue. In addition to being disruptive to family laws and families that transcend borders, this is both unnecessary and unconstitutional. It's unnecessary because the Supremacy Clause already ensures that foreign and religious law cannot supersede U.S. law. So any problem that Senate Bill 486 purports to solve is already prevented by the Supremacy Clause, so we simply don't need to do that. Finally, as I already addressed at the beginning, this is unconstitutional because despite the facial neutrality of the language, this aims to ban the religious law of one particular faith, and facial neutrality cannot save bills that are clearly motivated by animus. This is a textbook First Amendment violation. For all of those reasons, I ask you to please vote no on this bill.
I'm going to stop the clock. A question for you.
Yes, sir.
So based on your testimony to current law, how would a court treat those two examples you gave in family law differently than any other case coming before them under current law? And then if this bill passes, what will be different in those cases?
Wish I had the paper in front of me. I think better when I can look at paper. So, for example, what this would look like would be, if I'm not to wish divorce on Robert, but if they were getting divorced, it would essentially be like looking at a prenup that was done in Bangladesh under Bangladeshi law, right? And so then the court cannot base its ruling on a foreign piece of law, which is their marriage contract.
A court couldn't do that now unless that prenup met the specifics of Georgia law, right?
My understanding is that choice of law provisions would also protect. But yes, like nothing, because of the Supremacy Clause, as I already said, nothing unconstitutional is happening under these provisions already.
So is it safe to say his bill wouldn't change what's happening right now than in our states when it comes to family law and other types of cases, but your testimony against it is the intent is not good, potentially targeting a certain group, therefore the bill shouldn't pass?
I'm sorry, can you repeat the first part of the question?
Yeah, so if his bill becomes law, would we have the same results that we currently have then based on the Supremacy Clause right now when it comes to divorce cases, other types of civil cases in our state?
I'm not sure. Just to be honest, I will call the lawyers who are smarter than me and get back to you. Oh my God, I just noticed the actual jar. I am a lawyer. I just don't know the answer to that question.
You don't
so
have to,
I'm going to
yeah.
go call the other people and get back to you. I think that's a good question. But I will circle back to the fact that it is, because of the fundamental motivations, it's still unconstitutional regardless of what the practical impact would be.
Okay. Any other questions from the committee? All right, thank you.
Thank you.
And I apologize, is it Harwani? Yes, Shawani, come on up. Yes, ma'am. I see the S now. All right, Ms. Shawani.
Hello, everyone.
Hey, good evening.
Good evening. My name is Jawahar Sharwani, and I am a Muslim. I was here for something else, and I was about to leave. Then my friend mentioned they are staying for the Sharia law bill. I was shocked. I never heard anywhere of Sharia being applied in the U.S., so I decided to stay. I want to tell you that Sharia tells us to obey the law of the land that we're in, not to try to enforce Islamic law into those around us. I was shocked that this bill was actually presented, and I'm still shocked. This is silly, and it does not reflect on reality anything. So please oppose the SB 486.
All right. Thank you. No questions.
Thank you.
And the next name, is it Y-A-Y-O? How do you pronounce your name? I'm sorry.
Hello, my name is Aisha Yacoub. I am speaking as a resident of Cobb County and someone who's called Georgia home for the last 25 years. I know it doesn't explicitly say in this bill that it is about Sharia law, but as we've established, that was part of the initial intent of the bill. And I know when many people hear those words, Sharia law, they often imagine something dangerous or foreign, as this bill suggests. But for me and many other Muslims, it simply means living my faith with integrity, discipline, and responsibility. Sharia guides me to seek interest-free loans so that I can avoid paying interest, which you all know is insanely expensive. It teaches me to give 2.5% of my wealth to charity each year. It encourages me not to drink alcohol, which we all know is better for our health. And right now, during the month of Ramadan, it calls me to fast each day from dawn to dusk, from dawn to sunset, building patience, gratitude, and empathy for those who struggle. Just as importantly, my faith teaches me to obey the laws of Georgia and the United States, to be a good neighbor and a responsible citizen. These are just some of the examples of how I follow Sharia in my daily life. None of them threaten anyone. None of them undermine our legal system. Muslims use Sharia to guide our personal decisions using our faith, while fully respecting the laws of this country, as the previous speaker mentioned. These anti-Sharia bills don't protect anyone. They single out Muslims and turn our beliefs into something to fear. We do not need unnecessary measures that seek to vilify our communities and divide neighbors. I strongly oppose this bill, and I ask that you choose understanding over fear, unity over division, and respect over suspicion. And just as another note, I've advocated in this building for many years and lobbied many of you all here on a number of issues. Not once have I ever tried to encourage you all to adopt Sharia in any of your bills. That is not our aim here today. We're simply trying to showcase how we use Sharia in our day-to-day lives as the means to which we live, and why it is not something that needs to be legislated further over.
All right. Thank you. Is it Ms. Shaw that's next? Mr. Shaw. Come on up. Good evening.
Good evening.
And by the way, we have 13 minutes and 20-something seconds left. So.
Thank you, Mr. Chairman and committee members. My name is Rahim Shahun Khail, and I have been a Georgian for the past 35 years. I'm a business owner. I have multiple businesses in Georgia, South Carolina, North Carolina, Kentucky, Indiana. And I was traveling to South Carolina, but I got a bunch of messages and emails from my community members that there is something going with Sharia law, and there is a bill that's being passed targeting Muslims. And then these people start sharing this video with me, and the video, it specifically talks about Sharia law coming to Georgia. So I'm shocked and surprised because I really don't know what Sharia law is. In fact, there are 57 Muslim countries in the world, and I know of only 2 countries where there are Sharia laws. I was born in Pakistan. There is no Sharia laws. 98% of the population is Muslims. We don't have Sharia laws. And if you look at the constitution of this country, it clearly says that no religious or no foreign law can supersede the law of this country. So I don't know why we're creating these anxieties and fear-mongering in certain communities. We're being targeted continuously. There's a lot of fear in our communities. And I'm here just to have this understanding among ourselves that we're human beings first. Yes, we're Christians, we're Muslims and Hindus and Buddhists and all that, but we're humans first. Why are we going so far to target one specific community? And these are very productive citizens of the state. We're doctors, engineers, business people, taxi drivers, restaurant owners, but we feel very enlightened, very isolated, very being targeted. So my my request is that Georgia faces a lot of challenges when it comes to poverty, homelessness, or infrastructures or business, challenges. Let's focus on them. Let's come together, work together, so we can solve these issues for Georgians. If the author of the bill has different intention, I would welcome him and all of you to come to my house. Let's have a dialogue. Let's talk. Let's understand each other, because we love this country as much as anyone else would. Okay, we have cemeteries here, so that means we're going to die here. We're going to be buried here. So I would strongly recommend, if I need to talk to the author of the bill, I would be more than happy to take him out for a dinner. It's on me. But I think we need to have understanding for each other, and let's not target one specific religion, one specific community. Thank you very much.
All right, thank you. Next, we have Mr. Is it Fahim?
Yes.
All right, come on up. Thanks for being with us. Good evening. We still have 10 minutes left.
Good evening. Thank you for having me. I just wanted to reiterate a few of the points that were made by my brothers and sisters, and just share some insights related to what exactly Sharia law is. In fact, even when I say Sharia law, I'm kind of saying something silly, because I'm like kind of saying law, because Sharia kind of comes to mean law nowadays. But if you look at the original meaning of the word, and I kind of can share some points about this because I teach Arabic and I'm a student of Arabic. If you look at the origins of the word, actually what it meant was a path towards water, and specifically water being a source of life. So really what this is a path to life, because the laws of God are meant to be a life-giving source. So when we talk about the Sharia, what we're talking about is a ethical and religious framework that gives Muslims guidance around how to have a relationship with each other and how to have a relationship with God. So much of the Sharia talks about points like how to fast, how to pray, how to give charity, how to be a good neighbor, how to do all kinds of different things. And yes, there are certain things that are also mentioned related to states, things that pertain to what the state should be doing. But the Sharia encompasses an understanding of jurisdiction, like who is responsible for carrying what activities out. That's not for you and I to just carry out without any knowledge, right? So there's experts and there's specialists and there's people with certain jurisdictions who are supposed to carry out certain parts of the law. But for the majority of what the Sharia includes, it's very much related to what the common man does on a day-to-day basis. So I found it very offensive when I came across the video where it felt like Sharia was being targeted, Muslims were being targeted, and it felt like we were being sidelined and vilified, when that's not the case at all, right? Like when we as Muslims live in this country, we live with the understanding that the Sharia allows us to and encourages us to live according to the laws of the land. And there are certain things within the scope of our personal life and family life that we're supposed to live by in order to win the pleasure of God. And that's something that we all do as per the Sharia law. But there's no malicious intentions, there's no reason for there to be suspicion, and there's no reason for the language that was used in that video that was mentioned earlier to kind of, it felt like demonize or vilify Muslims. So thank you, and I hope that everybody on this committee will oppose this bill.
You do have a question from the committee. Senator Bearden.
Yes.
Yeah, just real quick, thank you, Mr. Chairman. I've heard the comment video a couple times, but what this committee does is look at the text of the bill that's in front of it. I've looked at this many times. Can you point me in the direction of the bill where it specifically targets one group, like you said, Sharia, or does it just say foreign law?
Right, so I think the concern is that the bill seeks to use very ambiguous language, but the intention very clearly seems to be that the specific intent is going after a particular community using this kind of ambiguous language. But I can let some of my colleagues speak to that a little bit more if you have more specific questions about the actual letter.
ask if anyone's seen in the text of the bill.
I don't believe that the term is mentioned in the text of the bill itself.
It's
But
not.
again, right, so, but again, the intention seems to be to use cloudy language to then go after a particular community, as we saw on social media.
I appreciate your answer, but I think it's pretty clear, but I appreciate it.
All right, thank you.
All right, next we have 7 minutes still. Mr. Is it Nadeem? Come on up. Good evening.
Good evening. My name is Mohammed Nadeem, and I'm resident of Georgia for last 21 years. And when I heard about this bill, and especially about that video, it not only offended me, but I saw this of a fear-mongering attempt, and so I just present here to oppose this bill strongly. So I would request the committee member to consider it.
All right, no questions from the committee. Thank you. One of our colleagues has signed up to speak as well. Senator Parks, do you want to come down? We still have 6 minutes and 41 seconds remaining. No pressure, don't talk too fast.
I'm known for talking too fast. Well, thank you, colleagues. I'm here to speak against Senate Bill 486. This bill was dubbed as the anti-Sharia law bill in the selfie video that Senator Greg Dolezal put out. Yet, if we look throughout the bill, it does not mention Sharia once at all. Not a single time is Sharia mentioned in this entire bill. When a bill is marketed one way but written another way, we should ask what we are really trying to accomplish here. The United States Constitution, as many people before me mentioned, already contains the Supremacy Clause. I'm sure all of you on the Judiciary Committee understand how that works. Judges are already bound by that framework. So federal constitutional law is the supreme law of the land. Also, Senator Greg Dolezal mentioned that he's banning foreign law when it comes to criminal, civil, and family law. His own bill actually makes a carve-out for civil transactions for international businesses. Now, when it comes to foreign law and family matters, when I got married, when I married my husband, I got married under, two ways. So it was under Islamic law, which is called the nikah, and which is a marriage contract, and it was recognized by my religion. And I also got married by a judge. So what this bill potentially will do is ban the ability for marriages to be recognized by our respective religions. So we're spending taxpayer dollars to send a harmful message to minority communities, Muslim Georgians, and it's deeply concerning. We're doing this in the time of the Ramadan, like we're just super slap in our faces. And we should not waste taxpayer resources on symbolic bills that solve no real problem and instead risk demonizing our neighbors. As a state senator who happens to also be Muslim, I do not want Islamic Sharia law to be law of the land. I want us to abide by American laws. In fact, to be clear here, there's never been a single instance of an American court that has abided by Sharia law. Georgia deserves thoughtful, necessary legislation, not fear-based messaging. And as your own Muslim colleague, I ask you to vote no on this legislation that creates Islamophobia towards your Muslim neighbors. Thank you.
I have a question. How does this bill itself put at risk anyone still going through their church or their faith to get married? If the current law is, we have state law, how we recognize marriage, but individuals, as you mentioned, still go through their church, but they still may make their marriage legal in Georgia by going through another protocol in the event whatever you do through your church is not recognized under Georgia law. So how does this bill undo that?
So, from my understanding, and correct me if I'm wrong here, lines 38 through 41, in your words, what does that do?
Well, that is confirming what other types of contracts that we recognize as far as prenups under Georgia law. And so I think what that is trying to do is carve out an exception when it comes to corporations may have like an arbitration clause where you may agree to to go and deal with civil matters in a certain way. I think he has an exception that still allows that, but that confirms that we're still going to have, under Georgia law, prenups enforced as they currently are, and still have domestic law be the same under Georgia law. That's my understanding of it.
So lines 38 through 39 says, however, that the exception provided by this paragraph shall not apply to domestic relation contracts, including but not limited to antenuptial agreements or contracts, divorce agreements, adoptions, etc. So it takes it out.
So the code section would apply to those types
Yes.
of agreements, correct?
Yes.
So, but going back to my question, so if that's the case, how is this bill changing what our current law is as we're currently operating when it comes to recognizing marriages, such as your own marriage, as you mentioned? How would your own marriage be threatened by this bill passing?
Because of this exception that has been put in this bill.
Well, the exception deals with where the code section will not apply. So I believe what the author's doing with that exception is still saying we're going to only recognize prenups and divorce agreements that are consistent with Georgia law.
Okay. Is that the understanding of everyone on the committee? Because
Well, I'm asking you though, because
Yeah.
you testified that this would put at risk marriages in our state.
From what I understand and from what several of my colleagues understood is that it would change it. And so if that's the case, then I think this is a flawed bill. It should not move forward. But if you're saying that it doesn't change it, I just don't see what the point of the bill is in the first place.
Well, it goes back to your statement earlier. Your statement seems to be, and correct if I'm wrong, is the law already protects us. We're not going to have foreign laws, whether it be religious laws or other countries' laws, enforced under Georgia law already. Therefore, this is not necessary, and the bill is targeting a certain community. Is that, in essence, part of what you testified to?
The author of the bill is in a video saying that this is an anti-Sharia law bill. So yes.
Okay, so is there anything under this law, as you see it now, that changes how we currently do things in Georgia when it comes to enforcing any international law, whether it be religious law or other countries' laws?
The only exception I see where it would change it is those lines 38 through 41. You and I seem to have a disagreement on that, but I mean that's where I stand on this bill.
Okay. Any other questions from the committee? You do have another question. No, there's 2-3 others, I believe.
I gotta pick. Oh, go ahead. I gotta pick up my kid from daycare. Okay, you're good. Okay.
You want to ask her now? Okay. All right. Thank you. All right. We have 4 minutes left. Next.
We need more lawyers.
Al Adros. I was close. Come on up. And then on deck, Susie Voles, were you testifying for or against it? You signed up on both sheets.
I must have signed up on I'm testifying for.
For. Okay, there's one other person, Tori Branum, that signed up to speak against. So you are the final two and against. We have 4 minutes left, so go ahead.
Thank you, Mr. Chairman and members of the committee. My name is Habib Alaidrous. I am a resident of Forsyth County, Senator Dolezal's district. Thank you for this opportunity to speak against this bill. I know we've mentioned this a number of times. This bill doesn't mention Sharia, but that's what the intent is, and my senator has made that clear in the video that he made a few days back. It transparently aims at stigmatizing one religion rather than any real legal concern. And the notion that Sharia law is infiltrating American courts or governance is not a constitutional reality. It is a recycled fear narrative deployed for political gains. Every American, regardless of faith, whether you're Jewish or Christian or Hindu, you should be concerned when you have the government officials using legislative power to stigmatize one religion and setting a precedent that endangers everyone's freedom. This singles out one group for disfavor, and it attempts to do precisely what our founding fathers sought to prevent when they crafted our Constitution and Bill of Rights, which is deny fundamental rights to a group of citizens based on a vote of a state legislature or the results of a statewide referendum. This bill wouldn't be right even if it's, written the way it's written, very vague language, but targeting the Jewish community or the Christian community or the Hindu community, and it is not right if it is targeting the Muslim community. With that, I urge the committee members to not pass this bill. Thank you.
All right, thank you. And our final speaker opposed is Tori. Is it?
I'm for the bill, sir.
For the bill. Got you on the wrong side. Okay. Well, that concludes our testimony against the bill. Come on up, Ms. Tori Branum. Am I saying it correctly? Yes. Come on up. We will now start the clock. There's 3 speakers speaking for the bill. But I don't think y'all need the full 20 minutes, right? Okay, good.
I wrote it down because I wanted to not leave anything out. First, I want to say I'm not acting on emotion. I'm not acting on fancy laws. I'm acting on someone that has lived experience. I am a congressional candidate for Georgia's District 12, but I'm also a Marine veteran that served during the War on Terror. And since they wanted to bring up Sharia law, and that seemed to be the main point that they were driving home, they felt there was some prejudice there. I want to read this to y'all. And I've been covering some projects going on in our state that are deeply concerning to Georgians, and we are facing a spread of Islam. Texas is currently ground zero, and that's Marine Corps terminology for what could potentially be a civil war. We are fourth in line. If we don't look to them as an example of what can happen when you aren't paying attention, we will have problems we cannot fix. With that said, I'm a mom of 7 daughters. That's right, 7. And when you're raising 7 girls, you think very seriously about the future you're leaving behind when you leave them on this earth, should things go in natural order. Right now, they have a Marine mom standing watch for those who took an oath to defend this country against all enemies, foreign and domestic. Sorry, this really hits home with me, so. This oath never expires. I lost friends in the War on Terror, and I understand the implication of what radical Islam is capable of. Right now, House Bill SB 486 in the Georgia State Senate would ensure no foreign religious law can ever override our Constitution in this state. That is not racism or prejudice. That is preventative measures and protection. This legislation protects women, children, and vulnerable parties from being disadvantaged by foreign legal systems that do not recognize equal rights. And let me be very clear, I support it 100%. This is not about attacking anyone's right to worship. We live in the greatest country in the world because people like me protected freedom of religion and served to protect our Constitution. But freedom of religion does not mean replacing the Constitution with religious rule. We have seen what happens when that line gets blurred. Look at Iran before 1979. Women were doctors, lawyers, teachers. They chose what they wore, they had careers, they had voices. Then in the blink of an eye while they slept and went on with their daily lives, an extremist regime took control. And in a matter of months, women were forced to cover their hair, their bodies, their laughter, their opinions. They couldn't dance in public, they couldn't sing freely, they couldn't speak loudly. They went from citizens to controlled subjects. And this is not a Republican or Democrat issue. This is an American issue. This is what happens when religious ideology becomes state law. Now, 25 years later, tens of thousands of women, offspring of those who allowed it to happen, are losing their lives for freedom in Iran. And we better look in the mirror. And I will tell you something, as long as I have breath in my lungs, that will never happen to my daughters. Georgia is governed by the United States Constitution and Georgia law, not by religious doctrine from anywhere else in the world. Preventative measures are not hate. They are common sense, protection, and wisdom. We welcome anyone who comes here legally and respects our laws. We defend the right of every person to worship freely. But we do not surrender our legal system. We do not compromise women's rights. We do not trade liberty for political correctness. And we do not apologize for saying America is built on constitutional governance, not religious rule. My daughters deserve freedom, your daughters deserve freedom, and if we have to pass laws now to make sure that freedom is protected for the next generation and the next generation and the one after that, that's exactly what we should do. Because once rights are gone, they are not coming back. We are not going to wait until it's too late. Not in Georgia, not in America. In closing, it costs you nothing to pass the bill, but it can cost you everything if you don't. People can say Sharia is not an issue. And that depends on how you look at it, because it is a derivative of Islam. And you cannot separate the wheat from the tare, the bad from the good. People come in all different forms, good and evil. And in this Islam radicalization that's going on, you cannot separate. And so there's nothing wrong with having a roadblock in place. It hurts nobody. But you can lose everything by not passing this bill. It needs to be a good, nice roadblock put in place. And I don't need a fancy law, and I don't have to be a lawyer. I have lived experience. I've seen what happened from serving in the military. and the experiences of my friends and losing friends. And so I can also turn on my TV and look at what's happening in London and Western Europe. And I feel like the preventative will actually make it'll be a lot easier for people to, it'll give people peace of mind with everything that's going on. So that's all I have to say about it.
All right, no questions from the committee. Thank you.
Okay, thank you.
Sorry. All right, Mr. Thomas Weaver.
Mr. Chairman, I'll waive.
All right, Mr. Weaver waives. That leaves you. Ms. Voles, come on up. Susie Voles. I believe I covered everybody.
I'm sorry that I signed the wrong list.
That's okay.
First of all, I want to thank you all for remaining here this late. I know that there are so many things that are pressing on you, including probably a nice, quiet dinner at home. Hopefully you can do that. I'm Susie Voiles. I'm a wife. I'm a mother. And now I am a grandmother, which is probably the best job I have ever had. One of the things I would like to remind people, there is a title on this bill. It is American Laws for American Courts. And the reason it's that, it is not singling out anything as we have heard today. We also have Chinese courts that are popping up in our country. We have to make sure that this covers more. And that's why it has a simple bill. It was not singling out anybody. But I think one of the things that we have to realize is we are currently facing the consequences of mass migration and the importation of ideologies that are fundamentally incompatible with American values and Western civilization. And before you think that I am anti-immigrant, I am married to an immigrant, and my son-in-law is an immigrant. Both are naturalized citizens. So this has nothing to do with immigration, legal or otherwise. In 1802, Mabry versus Madison stated, the U.S. Constitution is the supreme law of the land. That was 1802, I'm sorry. We talk about laws that are here and are not here, but on the other hand, there are hundreds of reported cases throughout the U.S. where they have attempted to apply foreign law and often have succeeded, even here in the state of Georgia. And I will be happy to submit to the record, I have pages of those laws where these have gone to court cases. One of the tragic ones here in Georgia was one where a mother was being severely beaten in Pakistan. Her uncle and aunt who lived here wanted to help her and her children escape that. She was not afforded those privileges here. They were able, she was able to come here. Because she came here and lived with her aunt and uncle and her children, the father divorced her in Pakistan, and when he divorced her there, he divorced her for the reason of abandonment, and then he accused her fallaciously of adultery because she was living in the home of her uncle. Nothing could have been further from the truth. The other issue with this was then, because he did this over there, he was able to come back, and the wife remained here, but the two children had to go back with their dad. We are seeing examples of this over and over and over, and they particularly are in the area of child custody judgments or jurisdictions. And there is gender discrimination, and we can't have that. That's already been thoroughly covered. I'm not going to go back there, but the Free Exercise Clause of the First Amendment of the United States Constitution protects religious exercise. However, the Congress and the United States may regulate activity that is not solely religious in its observance, even though a religion may claim that the practice is essential to religious practice. For example, the U.S. Supreme Court has upheld bans on polygamy, even though some Mormons have claimed the practice to be religious. Courts have also upheld bans on Native Americans smoking peyote and the KKK from wearing hoods, even though the claims were these practices are part of their religion. I think the thing that we have to realize, I was not going to bring up Sharia, but since it has been brought up, Islamic Sharia governs practices that would be adjudged as religious exercise, such as rules on praying. But Islamic Sharia also includes the regulation of matters which are part of civil law, such as marriage, divorce, child custody, marital property, rules of evidence, regulation of speech as blasphemy. The application of those aspects of Sharia can be banned by Georgia as a foreign law that violates Georgia's constitutional norms. Americans for 250 years have toiled and suffered. We're celebrating our birthday this 4th of July, including the spilling of blood towards guaranteed fundamental constitutional rights by war against foreign tyrannies and domestic insurrection, by engaging in social and political movements such as the suffragette or civil rights movements, and by creating landmark legal precedents. No U.S. citizen should be denied the fundamental liberties guaranteed in our constitutional republic. No U.S. citizen should be held accountable for something from a foreign country. Women and children are the common victims of discriminatory foreign laws, and they especially deserve the protection that is provided under our United States and Georgia constitutions. The intrusion of foreign laws, including Sharia, into the American legal system should be resisted. I not only want to thank you for your time, but I want you to remember what this bill was named. It was named American Laws for American Courts. We see other courts, as I mentioned earlier, like Chinese courts popping up. And I'll leave you with what the Federalist Paper number 78 said. He described the judiciary as possessing neither force nor will, but merely judgments. The courts were designed to interpret law within constitutional boundaries. The modern judicial activism often crosses that line. Original meaning means something. We have to protect our American laws for American courts. Thank you for your time.
Thank you. No questions from the committee. All right, Senator Dolezal, you want to come back up and close it out and let you take any other questions the committee members have?
Chairman, I know you have other bills. I'd be happy to answer questions. I think that the committee's kind of heard both sides of this, as well as I think what was your understanding of the bill. So,
any questions for the author from the committee? Or what's the pleasure of the committee? We have a motion to pass by Senator Bearden. Do we have a second? We all sound the same. Motion to pass by Senator Hatchett, second from Senator Bearden. Any discussion? All those in favor of the motion, please raise your hand. It is 3. All those opposed? It is 3. The chair votes in favor of the motion, so the motion carries 4-3. Thank you.
Chairman, members of the committee.
All right, 2 other bills on the agenda. Next is Senate Bill 327. Senator Parent, you want to go down there or you want to stay where you are? Okay. All right, let's remain orderly as we exit. Please do not speak to each other. And please, let's just exit the room.
Thank you, Mr. Chairman and members of the committee. It's a long hearing for us today, so I'll be real fast. I am presenting for your consideration Senate Bill 327, and I do want to thank the chairman and the committee for hearing this piece of legislation. This particular bill would provide for a 6th judge for the Clayton Judicial Circuit. So I want to just briefly give the history here. Clayton Judicial Circuit is actually the highest workload circuit in the entire state. It was not forwarded to this committee as the highest workload circuit in the entire state, and that's what I'm going to explain. And I have some documents in your packets that you can review to kind of see what the timeline is. Essentially, but the history is in 2020, Clayton Judicial Circuit was approved for the list of circuits that were in line for a new judge, and it remained on the list for 4 years, because typically it's 3 until you need a renewal. But in this instance, it was 4 because the pandemic was in there, and they sort of essentially, the Judicial Council left the circuits that had made the list the same for that next year. So what our practice has been, most of you already know this, but I guess I'll quickly go over it. The practice